Hello, this is Ted Strauss with Surplace Media. Today I'll be speaking with Joshua Blum, an attorney representing Chelsea Manning, who was refused entry into Canada on September 22, 2017. Chelsea Manning is a former U.S. Army intelligence analyst who became a whistleblower when she leaked a large amount of classified data to WikiLeaks in 2010. This leak included evidence of war crimes committed by the U.S. military in Iraq. She was imprisoned from 2010 to 2017. U.S. President Barack Obama commuted her sentence before leaving office, and she was released in May of 2017. Joshua Blum is an attorney with Jared, Will & Associates in Toronto. Welcome, Joshua.
Thank you for having me.
Can you describe for us what happened in September?
Sure. So on September 22nd, 2017, Chelsea tried to enter Canada at the St. Bernard-de-la-Colle port of entry in Quebec. She disclosed to the officer that she had been convicted in the U.S. for the crime she had been convicted of, and the officer formed the opinion that she may be inadmissible for serious criminality. The officer then referred her case to a hearing at the Immigration Division, which will give a final determination on whether she is indeed inadmissible to Canada.
Given that, what is the legal case that you are making on Manning's behalf?
Right. So to understand this case, it's necessary to know a little bit about Canada's fairly convoluted inadmissibility system. So basically where the process starts is an officer forms an opinion that someone might be inadmissible. That's what happened to Chelsea at the border when she told them about her convictions. The officer then writes a report, and they transfer it to another officer called the minister's delegate. And the minister's delegate basically decides what to do. So they can refer it to an inadmissibility hearing, but they also have discretion to say if nothing is to be gained or the objectives of the act aren't met by an inadmissibility, then there's no need to pursue a hearing in a given case. Basically, this discretion is like a human at the beginning of the process to say, what are we doing? Why turn on the inadmissibility machine in this case if there's nothing to be gained from it? So to clarify what our request is about, it's basically asking the officer to say this is a kind of case where nothing is gained for Canada from pursuing an inadmissibility. And that kind of request, it's rare, but it's fairly common that it's made. It's made in cases where there's an entertainer or an athlete who wants to enter Canada who might have criminality in their past. Canada would say, none of the objectives of the act. No, there's no danger, and there's no sense of international justice at play. There's no reason to take this to a full hearing. So in a case like that, they exercise their discretion not to pursue, not to fight to keep the person out of Canada. So we're asking for them to exercise their discretion in this case.
So your request is directly to the border services and not to a court?
That's right. It's to the minister's delegate. So the delegate of the ministers of public safety, who's the one who made this decision.
And who is that person? Who's the minister?
It's an officer at the border at St. Bernard-de-la-Colle. Okay. But also they have delegated power of the minister of public safety. So the minister of public safety can also make this decision in their place.
I see. And so has there been any response from the Canadian Border Services, and what could be the next steps, or what could be the next possible responses?
So there hasn't been a response yet. Either if they grant the request for reconsideration, that means they say, now that we've had a chance to look at Chelsea's case, see the outpouring of letters from civil society that have come forward in her case and really understand the facts, then they may grant reconsideration, and in that case, there would be the inadmissibility report would be rescinded. There would be no inadmissibility. If they don't reconsider, then this case will be referred to a hearing at the Immigration Division. And so at that hearing, basically, the Minister of Public Safety would be arguing and trying to prove that what Chelsea did in the United States is equivalent to a serious crime in Canada. She was entering Canada to visit friends, and she also hoped to kind of set the groundwork for a series of speaking tours in Canada. In terms of why there's no need for public money to be spent fighting to keep Chelsea Manning out of Canada, it really goes to this discretion I spoke about, and this overall question of a human being at the start just saying, what are we gaining here? Are the objectives of inadmissibility met by pursuing a hearing, an inadmissibility hearing in this case? So the reason we hold people inadmissible, it's to fulfill two objectives. It's for public safety and for international justice, to stop fugitives from coming into Canada. And what we're basically saying is neither of these objectives are at play in Chelsea's case. No one with a straight face says that she's a forward-looking risk to Canada's safety. Her crime was a crime of a whistleblower. It's confined to a specific set of circumstances. And then in terms of international justice, she served her time. Whatever you think about what she did, she served 7 years in prison, in an all-male military prison, and with frequently being subject to solitary confinement. So she was released by President Barack Obama because he said it's in the interest of justice that she be punished no more. So basically what we're saying is, why use immigration law as a collateral punishment in her case when there's none of the objectives, none of the reasons we pursue inadmissibility are here for her.
And what has been the reaction from Canadian civil society activists? What has been that response? And if viewers are interested in knowing more about it, what could they do?
Right. So there's been a huge outpouring of support for her case. We were able to submit more than 40 letters of support from different individuals and organizations. It included Naomi Klein and Avi Lewis, Amnesty International, the Canadian Journalists for Free Expression, many, many more. That's just to name a few. If people want to get involved, the best thing to do is to write to your member of parliament first. Your MP is the one you should be telling if there's something that the government can do or an injustice that they can easily remedy. The MP is basically your voice. So I would recommend writing to your MP and saying, if you don't think Canada should be spending public money fighting to keep Chelsea out of Canada, say, this is a case I support. I really don't think we should be relitigating her case. If you want to get involved more broadly, there is the person who's leading the organizing for Chelsea. Her name is Lex Gill, and she can be reached at lexgill@gmail.com, LEXGILL@gmail.com.
Canada, especially Quebec, is seeing a record number of asylum applications in the past year. If Canada makes what some might consider to be an exception for Manning, who her crime has been equated with treason by some. So if such an exception is made in this case, would that make it easier for migrants who have criminal convictions in their past to enter Canada? Would it change the immigration into Canada?
Right. It would not change anything because Chelsea's case is exceptional, but what we're asking for is not exceptional. This discretion has existed since the time of the beginning of our Immigration Act, and it's existed for many years specifically for this purpose, for a human being to say, why are we doing this? It's especially to be used in cases where someone is not a threat to public safety and where there's no objective to be met. And in fact, the objectives of the Immigration Act in certain cases are undermined by not letting someone in. If someone is a speaker that we can learn from, and in the case of Chelsea Manning, she's a speaker that many Canadians want to hear about her experience as a prisoner, as a transgender woman, and as a whistleblower. So it not only undermines the objectives of the Act, none of the inadmissibility objectives are met. So this is not a new thing. It's exactly what this discretion was for. The last point I would make as well is that the reason this is an exceptional case is because in most cases there won't be really any doubt that something is a serious crime. If someone coming from the U.S. has committed a violent crime, then they will not be able to enter Canada under this inadmissibility. What we have here is a case where it's not even clear that the inadmissibility they've chosen or that any serious crime would apply to Chelsea's case. The crime that it's been equated to is treason, which actually has nothing to do with what she did in the United States. The essential elements of treason are giving documents to a foreign state for the purpose of harming your own state. She gave documents to WikiLeaks for the purpose of letting the public know about mass illegality that was happening in their name that would have otherwise forever been unseen. The other point is that there are some more similar provisions in Canadian criminal law. But what's a really interesting distinction is that the United States is one of the only countries in the world, or the only democracies in the world, that doesn't have a public interest exception or a whistleblower exception for unauthorized disclosure cases. Meaning that Chelsea couldn't say, hey, I was acting in the public interest, I was serving the public role of a whistleblower, and have a defense. Canada does have a public interest exception. So Canada would basically, it's not a question of simply equating the two crimes. It would be a very complicated, very politically sensitive and very expensive endeavor, as Canada would basically be arguing that her crimes do not meet the public interest exception, that the exposure of U.S. war crimes wouldn't be public interest under our Security of Information Act. So it would be an extremely complicated proceeding, and it's not entirely clear that she is inadmissible. So the question is why? Who gains from spending these resources fighting to keep her out of Canada, when really many people want Chelsea Manning in Canada to hear her voice, and if you disagree with her, to debate with her. There's really no downside to reconsideration in this case.
Joshua Blum is an attorney in Toronto who is representing Chelsea Manning in her attempt to enter Canada. Thank you, Joshua.
Thank you very much. Take care.